SJC-12738, Town of Sudbury v. Massachusetts Bay Transportation Authority.
Good morning. May it please the court. My name is George Pucci, and I represent the appellant Town of Sudbury.
Hang on 1 second, 1 second. So we can get the clock going. Okay. Yes,
Try to
you're
sneak
still-
in a couple of
you're-
extra
so you're
seconds.
still
Thank
Mr.
you.
Pucci.
Thank
Go
you, Your
ahead.
Honor. With me today is co-counsel Audrey Eidelman as well. This case involves application of the prior public use doctrine, applicable when a land acquired or taken for a particular public use is diverted to an inconsistent public use, and that requires specific legislative authorization in that case.
Okay, slow down 1 minute and just tell me as if I had no land experience whatsoever. Zero. What is the meaning of that easement on the land for the MBTA? What does that mean that they can do with it?
The MBTA actually didn't acquire an easement, it actually acquired the fee. It had a.
Okay, so it acquired a fee. So
Yes, Your Honor. There were two operative documents, and one is an indenture, it's called, with the bankrupt B&M Railroad. And by that deed, they acquired the right to, quote, to operate a passenger and freight rail service over the rail line rights-of-way that pre-existed with B&M.
So the MBTA acquired that pre-existing right-of-way over the land
Correct, Your Honor.
with an express fee saying this is what you can do with it.
Basically a fee, yes,
So
a
it's
fee
not,
interest.
it's not an easement, it's not an easement.
No, it's not an easement,
Okay,
Your Honor.
and it's not a taking.
It is a taking.
It is a taking,
That's prong
okay.
number 2.
All right.
These railroad rights-of-way, the title is always complicated. So in conjunction with that acquisition with the fee interest, they also did an eminent domain taking under their statutory authority under Chapter 161A. They're taking, and this is the central part of the case. The taking, quote, was for the purpose of providing and extending mass transportation facilities for public use, close quote. So they exercise eminent domain power through this land running through the town of Sudbury, and that's the right-of-way that's at issue in this case. They didn't
Who exercised that? Who exercised the right of way? Who exercised the power of eminent domain?
The MBTA did.
MBTA did.
In this case, yes, under a section of Chapter 161A, they do have public eminent domain power to acquire for transportation purposes. And in fact, that taking was, as I said, expressly limited to that public purpose of mass transportation for public use. What the town is arguing in this case is, under this prior public use doctrine, where land was taken for a particular public use, it can't just be diverted for any other public use without specific authorization, and not general authorization as the MBTA has under Chapter 161A over corporate property, but specific legislation specifically identifying that parcel, identifying the parcel at issue, and identifying the use to which it will be changed.
I understand the prior public use doctrine, that if it were to apply, it would require plain and explicit legislation to override it. But the prior public use doctrine is a common law doctrine, and the legislature by statute may override a common law doctrine. And why should we not conclude that the legislature, by enacting Chapter 161A, Section 3M, at least with regard to easements, overrode the common law doctrine and said the MBTA can grant any easements over any real property held by the authority, as will not, in the judgment of the authority, unduly interfere with the operation of any of its mass transportation facilities? Why is that not simply the ability of the legislature to say we're going to override by statute a common law doctrine?
The legislature absolutely has that authority. It wasn't exercised here, because that's again, it's a general authorizing type of legislation over their general property. Where the prior public use doctrine should trump that has to do with this particular parcel was acquired for a particular public purpose, used for such. In that case, they have to go back to the legislature to specifically identify that parcel and get specific authorization under special legislation, identifying it and advising the legislature of the proposed use. If a piece of property was acquired by the public entity under its eminent domain power, they're not free to do whatever they want under general authorizing legislation under the case law for prior public use. One instance where that would be relevant to Your Honor's example is with the one of the amicus briefs that was filed by National Grid talked about the specific statute that talks about a utility's right to petition for a grant of location to a board of selectmen or aldermen of a city to get a grant of location for to put a transmission line over public ways. In that instance, Your Honor, absolutely, that specific legislation giving that entity the right to make that petition and giving the board of selectmen or the alderman of a city the right to allow that grant of location. In that case, the specific statute specifically conferring that ability, that power, would in fact trump the prior public use doctrine, because it would trump the common law doctrine. There would be no reason for applying it because there's a specific statute specifically authorizing that particular land conveyance.
Does this have anything to do with the argument having to do with what the impact would be if we recognize your position on other transfers of land?
Yes, Your Honor. That, you know, one of the grounds that the land court has cited in denying the town's right to relief in this case is sort of a open the floodgates argument.
Right.
And that argument is totally wrong. But both the land court was wrong and the amicus briefs are wrong on that issue, 100% wrong. And the instances they give are just not applicable. An example, Article 97 land, which as you know, with recent case law from the SJC, that land is protected. If either it's specifically acquired or deeded with a deed restriction as such, or it's devoted to reasons specified in Article 97, that land cannot be diverted. So a government entity holding that land under Article 97 cannot simply divert it to an inconsistent use without getting a 2/3 vote of the legislature. That's one instance where you're talking about public land being conveyed to private interests for some type of private development or, say, a electric transmission line. Another example, and these are cited in the amicus briefs, they actually prove the town's point. Land held by a municipality for a particular public purpose cannot be sold to a private party without first following procedures and town meeting approvals required under Chapter 40, Section 15A. In that instance, town meeting is acting as the legislative body for the municipality. A municipality acquired land for a particular public use. They can't just do whatever they want with it without that legislative authority, specifically identifying the parcel and specifically identifying the reason that the use of that parcel is going to be diverted. Other examples right from the amicus briefs, which highlight the strength of the town's case. In the NIOP REBA brief, they cited schoolhouse or historic buildings being converted to affordable housing or commercial space. I'll point out again, town meeting approval is required that. First, you need a town meeting vote transferring custody and control of the building from either the school or whatever purpose that public building was held to affordable housing or for commercial purposes, again under Chapter 40, Section 15A. Town meeting approval is also required to authorize either conveyance of the fee title for affordable housing purposes or commercial purposes.
So is your point that the floodgates are not going to open because they can't open? Because there are other...
Exactly, Your Honor. This is a very limited circumstance where the prior public use doctrine comes into play with all these other specific legislative requirements. Just to complete the point on that, is the town would then have to either convey the fee title in that public building from school or other municipal use over to affordable housing or commercial use. They have to get town meeting approval for the conveyance of the fee title or ground lease, either one. They also have to issue a request for proposal. Even if they have the greatest thing since sliced bread in terms of a potential project, they still have to bid that out under the procedure provided under Chapter 30B. Another example of this, that there is no opening of the floodgates in this case. NIOP and REBA talk about the city of Worcester's plan to build a minor league ballpark for the Boston.
I'm not sure I get that. So let's take the MBTA, let's take the Massachusetts Port Authority, these giant independent authorities we have that, you know, have these sort of general, they're supposed to run an airport or a seaport, or they're supposed to run the transportation system. If they change any property use, like the MBTA is going broke, and they convert some dilapidated rail to something that makes money that helps pay for rail elsewhere, that's violation of the public use doctrine for you?
No, they have in fact, they have a mandate under the statute to enhance their revenue opportunities, so they can use MBTA.
They're changing the use. They're changing it from a rail to something else.
Well,
Doesn't
no,
that
they're not changing the use. They're not eliminating the use for which they acquired the property. They may, like in the instance of one of the
But
cases.
they're not here either, right? They're making money off of the transmission of the electrical lines, right?
Yes, but they're not.
And I assume they're fulfilling environmental commitments by creating bikeways. Is that wrong too?
They're not, yes, it is. Well, it's illegal, is what we're arguing. I'm not saying it's right or wrong.
Well, no, but
They're not.
no, but you said that they can make conversions as long as they're consistent with their stated missions.
If the property was acquired for a particular public purpose, they need the legislation specifically authorizing it. If the use is.
But remember, the MBTA is there it also needs to generate revenue. The same thing with the port and and the Commonwealth itself too. I'm just trying to understand, if you change a use to a profitable use to help pay for the mission of these entities, you're now saying that you build a rental car facility at the airport? That's not airplanes.
No, because
does that require a conversion of use? Is that a violation of the public use doctrine?
No, Your Honor, because
not?
the use would be incidental to the primary purpose for which that public property is being used. So if you take the instance of, say you go to South Station, and the trains come and go, and they lease out space to restaurants and whatever to go in, if that doesn't impede the use of that property for the mass transportation, and I don't know the purpose.
So they own
applicable
a
to that.
parking lot out in the middle of nowhere that no one's using, and then they sell the property to make some money. Is that, or they lease the property to make money. Is that a violation of the public use doctrine?
No, not necessarily, but it would.
How is that different than this?
Because it would matter if they acquired, how they acquired that title to that property. If they acquired it under a taking for a particular public use,
Yeah,
they may need.
to run transportation, to fulfill
If
their
it's
transportation.
incidental to, if it was acquired for mass transportation purposes, yes, I would argue that the prior public use doctrine would apply, that they would need special legislation, which is not an uncommon thing to get special legislation from the legislature, specifically identifying a property that was used for a prior particular public use and diverting it to another public use. In that instance, it may not apply because it may not have been acquired for a particular public use. Here, this property was taken by an eminent domain for mass transportation purposes. The other thing I would point out, Your Honor, is the use here is not incidental to mass transportation for public use. The new use will preclude the use for public transportation. And we have factual allegations in the complaint about that. Following the
Putting in the electrical, the power grid below it is going to preclude the use of this?
In this instance, it will, Your Honor. We have extensive allegations which must be taken as true for the purpose of a motion to dismiss, talking about the topography in this area. So in an area where the line will be located directly beneath the pre-existing railroad right-of-way, it's precluded because of insufficient ballast beneath that. If they do it outside of that way, but within the right of the entire 82.5 right-of-way of the MBTA, topography also, because of slopes and waterways, you can't construct a line there. So this new use is going to preclude active rail purposes. So it's inconsistent with the prior public use. And my red light is flashing, but one last instance, and you frame this issue in terms of diversion to a private use. And the key on that is, it's not whether it's a private use or public use which is relevant under the recent case law that the SJC has had on these issues, talking about the prior public use doctrine. It has to do with what the purpose, whether that purpose of the public land was acquired for a particular public purpose.
Chief Justice Piper, who is an expert in this, there are no cases applying it to the transfer to a private use. What is your, is there a case that?
One case, Your Honor, that I would point out, and it's cited in your Mahajan versus Department of Environmental Protection case, and you'll recall that involves Boston Redevelopment Authority property, and the court went on to talk about the prior public use doctrine. And by the way, the prior public use doctrine is still alive and well. It's not, it's not limited to parking.
Could you just answer the question?
Yep.
So there is a case saying that the public use doctrine applies when you transfer a public use to a private use.
One of the cases cited in Mahajan, when it was talking about the history of the prior public use doctrine, cited a case, Muir, M-U-I-R versus Lemonster. It was an appeals court case from 1974. In that case, the court held that the doctrine was inapplicable to the sale for commercial purposes of a parcel of land where that parcel had been conveyed to the city as a gift with no limitation on its use, but was in fact used as a playground and for other recreational purposes. The case held, in this case, there had been neither prior legislative authorization of a taking for a particular purpose, nor a prior public or private grant restricted to a particular public purpose. Therefore, the court held in that case that the prior public use doctrine didn't preclude the diverted use. Not because it was not because it was
Can you just, again, we're going to lose you, but just, did that case apply to a private use, a transfer from a public use to a private use?
Yes, a proposed sale for commercial purposes of that parcel of land. The court held that the doctrine did not apply only because it was not acquired for a specific use that was inconsistent with that, not based on the fact that it was going to be sold to a commercial entity.
All right, thank you.
Thank you.
Mr. Uwer, is it Hoover?
Good morning. Thaddeus Hewer on behalf of the MBTA. Mr. Chief Justice, may I please the court? The land court's dismissal should be affirmed, and I'd like to make 3 points here. First, this court is asking its amicus solicitation whether the doctrine should be expanded to cover private uses, and the answer to that is no. Expansion would supplant existing explicit legislative intent. It would run contrary to the doctrine's very limited purposes, and it would create significant adverse policy consequences for state agencies, private parties, and even municipalities like Sudbury. And even given this court's retroactivity precedents, even if expanded, it wouldn't apply here. Second, Sudbury lacks standing. Sudbury concedes it can't demonstrate an injury here, and instead contends that the Braintree case in this court created injury-free municipal standing by implication.
Do you think we can handle that matter even though there's no standing, or allegedly no standing, under our superintendent's power?
As you know, this case was briefed in the appeals court, so the arguments that we made there about stare decisis, obviously this court has power under Wellesley College and other cases to use its superintendent's power to reach issues where the parties don't have standing. That being said, Wellesley College is traditionally used in cases where standing has not been raised below and the matter has been fully briefed. It's not intended to give a pass to the lower courts to not have to address the issue of standing where it is plainly and manifestly raised at the time by the parties. And third, dismissal was required here unless all 4 prongs of the doctrine were implicated, and those are a subsequent public use. It was devoted initially to only 1 public use, that's the Muir case, a subsequent use that was inconsistent, and plain and explicit legislation. A century of uniform precedent, as the land court determined, holds that the doctrine applies only where the public use is on both the prior and the subsequent side. And here, Eversource is a private party with a private use. Sudbury lost on that prong below, but it fares no better on any of the other three. It needs to demonstrate all four in order to survive the motion to dismiss.
So you're not arguing 161A, Section 3M gives you the authority as a matter of statute and overrides the common law?
I am absolutely arguing that Section 3M overrides the common law. The plain and explicit legislation of the MBTA is manifest. The MBTA takes its statutory requirements very seriously, and its enabling statute, which is 161A, could not be more clear. It has a legislative right to alienate land. That's 3Q and 5B. It has a legislative right to grant easements, as you note, Chief Justice. It has a legislative duty, not just a right, a duty, to, quote, provide for the maximization of non-transportation revenue from all sources. That's Section 11. And this court in the Somerville case held exactly on that point, that the duty to maximize non-transportation revenue is, quote, statutorily integrated with the MBTA's, quote, essential function of mass transit. And here, in the doctrine context, Higginson, the case from the early 1900s, held that the plain and explicit test requires, quote, ascertaining the will of the legislature as manifested in its statutes. 161A could not be clearer. Repeatedly, there is explicit legislative intent that the MBTA be entitled to manage its real property without further intervention from the legislature.
So if the statute overrides the common law, why do we need to address the issue of whether the public use doctrine should be or should not be extended to private purchases?
I do not know, Your Honor. That was part of the amicus solicitation. It was in two parts. The first part was asking about this case. The second part, obviously not briefed by either party, was about whether the doctrine should be expanded. Seeing as the court asked about it, we are, of course, willing to provide significant commentary on that policy issue.
And I guess the question, I gather we don't have any or nearly no cases which apply the public use doctrine in the context of a sale to a private individual. But I don't know that we have any cases in which that was done, in which it was said that the public use doctrine does not apply either. We just have silence. So what do we do with that? I mean, it's sort of weird over the course of 200 years of the public use doctrine that we've yet to have a case in which anybody has sought to apply it in the context of a private sale. Why is that?
It's not unusual because the doctrine literally doesn't say that. It says the prior public use doctrine applies to a prior public use that is diverted to an inconsistent subsequent public use. The word public is on both sides of the equation.
I understand that, but I also know that Article 97, which is viewed as an extension of the prior public use doctrine, is not limited to other public uses. It would apply to the disposal of parkland to anyone, including a private property, including a private person. So, I mean, at least with regard to the Article 97, it is not limited to other public uses. It would apply to any use.
Correct, Your Honor. Article 97, and I'm happy to discuss Westfield in the context here. Article 97 is not an extension of the prior public use doctrine. It supplements the prior public use doctrine. And I think it's notable to note that Article 97 is an article to the state constitution. In other words, over 200 years had to pass before we determined that for conservation land to be converted to a private use, it required a constitutional amendment, not the use of the prior public use doctrine, because clearly the prior public use doctrine was never contemplated to have applied in those situations. In order for it to go from conservation land to private use, you now need a 2/3 vote of the legislature. And my understanding of Smith v. Westfield, although I would defer to you, Chief, is that the notion is that it was not intended to limit the prior public use doctrine, and we're certainly not saying it does.
Can I, or if you've adequately answered that. 161A, Section 3 talks about grant such easements over any real property held by the authority.
Correct.
So when the MBTA holds a right-of-way, is it in fact holding real property?
Absolutely. I mean, it will depend on how it is taken. Certainly, it can hold rights of way in many ways, but usually holds them in fee.
Well, okay, do you have a citation for that, or can you point me in the direction of something that would say that?
That the MBTA holds its property in fee?
No, well, that what I just asked you, that you said certainly, of course it would, is that just a logic application? Or is that an interpretation?
It's the literal fact on the
The
ground of
literal
how the
fact on the
MBTA
ground.
holds property. I mean, you'd have to go through the registry of deeds and see how it is acquired, each piece of property, just as you would for any property owner. But the MBTA traditionally acquires property either through purchase or it acquires it through eminent domain. It has the absolute legislative
Okay, but
delegated
it's
authority.
holding only a right-of-way, it's not holding the actual title to the property,
No, it
correct?
holds the title to the
It
property.
does, so it's
Yes.
not a right-of-way issue.
It is
It is?
It is a right-of-way issue. A right-of-way is merely how that piece of property is used. If it's dedicated as a right-of-way, particularly for a rail purpose,
Okay,
it becomes a
so-
rail right-of-way, and it has a specific
it.
meaning in the statutes and in the case law.
Right.
Do you want to address Muir versus Lemonster? Because he is right that they could have just said, hey, this is a conversion of a public use to a private use. But instead, the appeals court, and this Chief Justice Hale, who was a municipal lawyer, spends a lot of time avoiding the issue, right?
He does, but at the end of the day, the case stands to the proposition that the doctrine doesn't apply. Certainly, I'm not going to second.
But he kind of gets there very indirectly as opposed to sort of answering the question we have to answer, which is whether the doctrine applies to the conversion to a private use, right?
That's correct, Your Honor, but I would say that while the case may have interesting dicta and he could have reached that issue otherwise, the ultimate conclusion of the case is quite frankly what matters. And what it concludes is that there was more than one public use, and therefore there is no doctrine applicability. And I think the larger point is, again, going back to my notion earlier, that in order to survive a motion to dismiss, the town needed to show that all four prongs of the doctrine were met. Any one of those prongs defeats the town, which is what happened below. Judge Piper correctly noted that there is no subsequent public use. There is a private use. That ended the inquiry. The town, repeatedly states in this brief that Judge Piper found for them on the remaining three. He literally did not reach those facts.
Is that consistent sort of with the argument that you said before, that you say it is encompassed by the statute? So it is a public use, meaning when they take that when they give the money, give this to the electrical company and make money off of it and create a bike path, they're fulfilling part of their public mission, which is to generate revenue for the MBTA and to satisfy our environmental commitments to create these kinds of bike paths and other things. So isn't it kind of a public use?
So if you're asking about the bike path element of it,
I'm asking for both, because I read the statute the way the chief just read it to you, which is you're right that they can do these things, but at the same time, that means it is a public use, right?
there is no dispute that the MBTA is a paradigmatic public agency, body politic corporate of the Commonwealth. Everything it does, just like MassDOT or Massport or anything else, would be deemed a public use. But we need both sides of the equation before the doctrine comes into play. The MBTA on its side, certainly a prior public use. But the issue is whether the subsequent use is also a public use. And here
We
it
determine
clearly is
that.
not.
How do we, it's not a finding of fact by the judge. You can't be doing that in a motion to dismiss, right? You can't
Pardon
find, the judge can't find facts on a motion to dismiss.
Certainly he can. He determined as a matter of law. And we can also look to Share v.
As
Brandeis.
a matter of law, that it's not a public use.
As a matter of law, he found that Eversource was clearly a private company. And was
Okay,
using a
private company, but is
and
it a private use? Private
Absolutely.
company can have public uses though, can't it?
Not to my knowledge.
Okay, so that's the basic thing. You're saying a private company is dispositive. That's, private company means private use.
Absolutely, and I think if you look at this court's decision in Higginson, that's the 1912 case, the court actually discusses what a public use and a private use would be. And the court says in Higginson that this is a, quote, property of which a city or town, I think it would also apply to a state, has acquired absolute ownership as an agency of the state in which it holds strictly for public uses. And then it goes on to note that waterworks, sewage, gas, electric light markets historically have been treated as proper subjects for private enterprise, even when assumed by a city or town and have been regarded as private. Right? That's the case that we're all relying on. And that's what it says about what a public use is and what a private use is.
So help me to understand, put aside the 161A. Let's assume there was no statutory authority.
I'm happy
the
to win on that
MBTA.
basis.
And let's take a different case. Let's assume that the MBTA by eminent domain seized land in New Bedford in order to build an extension of a train line to New Bedford, and spent a great deal of money for it, and then ultimately said, no, we're not going to build the train line. We're going to sell it to a private developer for housing. Can they do that without any legislative approval?
They may, Your Honor. First, I would just clarify that they would not be seizing it. They would be paying just compensation pursuant to Chapter 79.
Okay, they're paying it through eminent domain, I understand that.
but they
I
have
mean,
acquired the land.
But the strange part is that if they said, we're gonna give it to the city of New Bedford to use for some public purpose, they would need legislative approval, correct?
Setting aside Chapter 161A and its express authority that allows them to utilize
Right.
their legislative authority to deal with land transactions without restriction, certainly that might be a situation because the city of New Bedford holds eminent domain authority. I think one suggestion I would say is that given the hierarchy of state, local, and municipal, that as we note in our brief, the purpose of the prior public use doctrine, one of its two main purposes, is to ensure that two entities with competing eminent domain power aren't using it against each other ad infinitum, and it sets a default rule. In that situation with the state and the municipality at different levels, one suggestion I would have is that that might not necessarily be the case because it's not clear that City of New Bedford actually has the delegated legislative authority to take from a state agency. If it did, then yes, that might be a circumstance in which the prior public use doctrine could apply. If it sells to the private developer, absolutely
How
not.
about in my hypo, if they want to sell it to a private developer to build housing?
Not covered by the prior public use doctrine. Subsequent use is not a private,
So they
it's not
could
a
just,
public use.
so there's no problem for them to do that, even though it had been seized for purposes of eminent domain
And
for what was to be a transit use.
That's
And
correct.
that's my problem, is understanding that leap there. I'm having a hard time with what Justice Gantz, I'm not with his question, but with what the answer is to that. It doesn't seem right to me that you can do this.
I think the question of what is right or not goes back to the notion of common law versus statute. The common law fills gaps. It doesn't supplant statutes. And it's an ancient doctrine, I get it, but the legislature has kept up with it. And over the years, in repeated enabling acts for all of the major landholding agencies, that's MassDOT, MBTA, DCR, DCAM, Massport, they all have express authority to have essentially unilateral control delegated by the legislature over their real property transactions. They all have the authority of eminent domain, and they can use eminent domain. I think the case law is very clear on this, that a property taken for eminent domain need not necessarily be used for that purpose. It goes into the general property bank of that entity, and it can be used for any purpose within the legislative authorization of that agency. They're all limited by statute. The MBTA can't go build a school. But it can certainly use it for any mass transit use. And it also has the authority and indeed the obligation to maximize its non-transportation revenue. So the legislature recognized that it could give the authority to take and acquire, and it also gave the authority expressly to alienate, either because it wishes to or because it wishes to enhance its non-transportation revenue.
That's actually a pretty broad power that it gave to the MBTA there.
Absolutely, same power for the MBTA, same power for MassDOT, same power for Massport. These are large public agencies, very sophisticated. They all have their own secretariat. They're responsible to the legislature. There's a recognition that literally in order to run a railroad, you need to give some discretion to the people whose job it is to run a railroad. And that includes determining in their best interests what is the appropriate way to manage their real property assets.
And there's no
including acquiring them.
supervision, there's no way of being able to say that they did it wrong or abuse their discretion?
I suppose there is, Your Honor, but again, that kind of goes to Chief Justice Gantz's point about Section 3M of 161A. The legislature has expressly given the MBTA the inherent and express authority to, quote, grant easements over its real property, quote, as will not, in the judgment of the authority, unduly interfere with the operation of its mass transit facilities. The legislature has expressly said, we are giving this to your judgment, MBTA. I suppose there could be an
Under
arbitration.
that, could the MBTA decide to sell most of its lines to a private entity to run for profit, allegedly?
It could, and over the years, it has disposed of its assets.
I know it has disposed of some of them, but how about the whole system? Could it use that?
That's not this case, because we're
I
not
know.
disposing of anything. But I think that's important. We're not disposing of anything here. The MBTA retains the right-of-way.
Okay.
It disposes of a term-limited easement, and that easement is expressly subordinated, as we note in our briefs, and it's in the appendix, to the MBTA's right to operate mass transit. If there's ever a situation in which they would be inconsistent, Eversource must, by the option agreement and then the easement, yield. That means they may have to remove the line if they need to use it for mass transit. MBTA is reigns superior in this transaction in every single one of the specific issues that will be raised by the prior public use doctrine. So yes, the MBTA can alienate its property, it can acquire property, and it does so frequently with a number of railroad lines. This rail line is disused. It was B&M's line, it was acquired in the 1970s. So in that situation, yes, the MBTA decided to acquire it, bank it for future rail transit purposes or other mass transit purposes. The town says it must be rail, but that's not inherently required. The MBTA is the Massachusetts Bay Transportation Authority. That includes buses, it includes bikes, it includes a whole range of other public transit. So the notion that it must be a rail line and therefore a rail line would be inconsistent simply isn't the scope of what the MBTA acquired it for on the face of the taking.
Okay, thank you.
Thank you, Your Honor.
Mr. Lewin, we've not forgotten you.
Good morning still. May it please the court, Joshua Lewin for Eversource Energy. I'd like to address three issues. Some of these have been touched on already, so I might divert a little bit. First is that the proposed use by Eversource of this right-of-way for a transmission line is not a public use. Secondly, I'd like to touch a little bit on the effects that would result if this court extended the doctrine to apply to utility companies' installation of a transmission line. And thirdly, I'd like to talk just briefly about the first two elements of the doctrine and why the town loses on those two elements.
Is it your assertion also that it's not a public use because it is a private entity?
Absolutely.
That's it? A private entity cannot put something to a public use?
Correct. There's really two elements. One, it's the user, and two, it's the nature of the use. And the phrase public use has a very unique meaning in the context of the prior public use doctrine. Mr. Hewer referred to the Higginson case, and I would suggest that the court look at that case. The Higginson case talks about public uses being where an agency of the government holds land and administers that land as a trustee for the public benefit, for the public at large, not for any narrow pecuniary purpose or limited benefit of the agency or municipality at issue. We're talking about things such as public parks. That was really the manner in which the doctrine emerged. Things like schools, highways, hospitals, those are the public uses to which the doctrine has been applied. And the court's right, in 200 years, it's never been applied to a subsequent private use. And there's a reason for that. Because outside of the parkland context, which has now largely been supplanted by Article 97, the doctrine has only been employed where you have conflicting taking powers, right? So you have two agencies, each of which have been charged by the legislature to, or given the authority to take property for specific purposes. And in that context, this court has said, we are going to leave it to the legislature to determine which of the competing public uses will prevail in that circumstance. That is certainly not the case here. Eversource is a paradigmatically private use. It is a for-profit corporation. The transmission line that will be installed will be used to generate revenue. And it's totally outside of the prior public use doctrine. If this court were to apply the prior public use doctrine to...
So then we can't stop with the question the Chief began with, which is whether this is within the MBTA's authority, because I take it the first step is transferring it to you is within their authority, right? So it's a public use for them to give it to you to use for a private use? I'm just trying to get a sense of where, are you going for too much here?
Well, I think as my brother indicated, any one of the four elements.
I know, but we've got a motion to dismiss, so I'm just trying to understand. You say that your private use is a totally private use, but you're fulfilling sort of a part of the public mission of the MBTA, so I get confused about why that's a totally private use.
Well, I see where the court's going there, and if I understand it, what you're saying is
Sure, I'm going anywhere, but I'm confused.
the MBTA's use in leasing it is the public use at issue. And if you look at it in that light, first of all, I would suggest that under the case law I was just discussing, even that wouldn't be considered a public use because narrow revenue generating uses aren't considered to be public uses for purposes of the doctrine. But even if you were to say that, still, the next element in the inquiry is whether they have express legislative authorization to do so. And under 161A, I suggest that they certainly do.
But do we stop there? You know, this seems to be a morass once we get into this. But do we stop with, the MBTA can do this under that statute, or do we have to then analyze this larger question of whether the public use doctrine can be applied to a private use down the road?
No, I would suggest there's no need to go that far. Once they lose on any one of the elements, that's it. And if there's express legislative authorization under 161A, I would suggest, yes, the court can stop right there. That's the end of the inquiry. Just briefly on the impacts if the court were to extend this. As the amicus brief of National Grid points out, utility lines and utility companies rely on public land to install and expand their systems. This single transmission line is a good example. It passes through a number of communities and will pass over a number of public lands. If this court were to extend the doctrine, it would literally paralyze the utility company's ability to expand and enhance their systems. Every time they would seek to add a line on a street or cross MBTA property or any other property given by a town or municipality or government agency, they would literally have to seek the legislature's express authorization to do so. It would be impossible to provide cost-effective and reliable service under those circumstances.
Okay, thank you.
Thank you.